Welcome to this explainer. Today, we're taking a chronological journey to completely demystify the legal boundaries of police power, your civil liberties, and exactly how an arrest works under the law. Whether you're a law student, a professional, or just someone who wants to know exactly what happens when the state steps in to restrict personal liberty, this deep dive is for you. We're going to break down the mechanics of an arrest using clear concepts drawn directly from legal sources. Let's get right into it. So here's our roadmap for today. We'll start with balancing power and freedom, then compare arrests with and without a warrant. From there, we'll look at the physical execution of the arrest and wrap up with your crucial rights upon arrest. This flow takes us all the way from the foundational philosophy of restraint right down to the critical charter rights that are triggered the very second you're taken into custody. All right, Section 1, Balancing Power and Freedom and the Principle of Restraint. We're kicking things off with the philosophical baseline of our entire criminal procedure, that very real tension between state control and individual liberty. The absolutely crucial point here is this underlying balance. The state's legitimate interest in prosecuting crime is constantly being weighed against Western democratic principles of freedom. It's kind of like a giant scale. The law really aims to reflect a principle of restraint, meaning even when police are given coercive powers, the fundamental rule is that they shouldn't interfere with your liberty without good reason. And even then, they must use absolutely no more force or interference than is strictly necessary. Now, to truly understand this balance, we've got to define what an arrest actually is. It isn't just about slapping on a pair of handcuffs. Legally speaking, it happens in one of two ways. It's either the physical seizure or touching of a person with the intent to detain them, or simply using words of arrest accompanied by that person submitting to the authority. Plus, and this is key, the law views an arrest not as some split-second event, but as a continuing act. It starts the exact moment custody begins and extends all the way until the person is either released or brought before justice. And this principle of restraint, it's baked right into modern practice. Since the legislative updates in 2019, specifically Section 493.1 of the Criminal Code, the law explicitly demands that officials prioritize releasing an accused at the earliest reasonable opportunity and on the least onerous conditions appropriate for the circumstances. Basically, the whole system is designed to lean heavily toward freedom, placing the burden squarely on the state to justify keeping someone locked up. Moving on to Section 2, Arrest with a Warrant and Judicial Pre-Authorization. This is exactly where the state officially asks for permission to tilt that scale and make an arrest. Before an officer acts directly to compel someone to court, they'll often go to a judicial officer, like a justice of the peace, to get a warrant. And this is basically a two-step hurdle. First up, an information is laid under oath, which is really just legal speak for a formal written accusation detailing the reasonable grounds to believe an offense was actually committed. But hey, that's not enough on its own. Step 2 is the critical filter here. The justice has to determine that issuing a warrant, rather than just, say, sending a summons in the mail, is strictly necessary in the public interest. Once it's issued, a warrant is an incredibly powerful tool. It's directed specifically to peace officers and can typically be executed anywhere within the issuing province. But notice the key exception here. If an officer is in fresh pursuit, meaning they're actively chasing a fleeing suspect across borders, well, that provincial boundary just vanishes, and the warrant can be executed anywhere in Canada. Also, significantly, arrest warrants do not expire. There's no expiration date. They simply remain in force, waiting until they are finally executed. Okay, Section 3, Arrest without a warrant and shifting the balance on the street. So what happens when police just don't have the time or the opportunity to get a judge's pre-authorization? To arrest someone without a warrant, an officer can't just act on a gut feeling or a hunch. They absolutely must satisfy a strict two-part test for reasonable grounds to believe an offense has occurred. First up is the subjective test. The officer has to personally and genuinely believe that grounds for arrest exist. Second is the objective test. A reasonable person, standing right in the shoes of that arresting officer, must also conclude that those grounds exist. It's not about absolute proof of guilt at this stage, for sure, but it has to be, it must be way more than just a mere suspicion. Our law also clearly separates who actually has the power to make these warrantless arrests. Section 494 outlines citizens' arrest. And actually, these powers descend directly from ancient common law. So no, citizens' arrests aren't just a thing for superheroes in movies. But the rules are very, very narrow. A regular citizen basically has to catch someone red-handed committing a serious indictable offense. Think something severe like an armed robbery. Meanwhile, Section 495 gives peace officers much broader preventative authority. It allows them to arrest based on reasonable grounds of an offense that has been committed or even one that is about to be committed. But think back to our scale of balance from the beginning. Even with these broad powers out on the street, Section 495(2) steps in to restrain police action. It tells officers that for lesser offenses, they should really just use an appearance notice, kind of like a ticket, instead of making a full-blown physical arrest. They're only supposed to arrest for these lesser offenses if one of 4 specific factors is present. They need to establish the person's identity, preserve evidence, stop the offense from continuing, or ensure the person actually shows up to court. Let's get into Section 4, executing the arrest, action, entry, and force. This is where we see what happens when the arrest goes from a legal theory to a physical reality. Now, this brings up a highly relatable tension point, one you've probably seen in countless movies. Can police simply kick down your door to make an arrest? I mean, does the law protect the privacy of your own home from police entry? Or does the power of arrest just trump your property rights? The answer actually lies in how the law treats a dwelling house. The landmark Supreme Court case R.V. Feeney confirmed that your home is indeed your castle. Police cannot just waltz in to make an arrest. They need specific judicial authorization, often called a Feeney warrant. However, the balance suddenly shifts back to the police in 2 major exceptions. First, exigent circumstances. So if there's an imminent threat of death, bodily harm, or the destruction of crucial evidence. And second, hot pursuit. Literally, if police are continuously chasing a fleeing suspect right through their front door. When it comes to the physical act of the arrest itself, the law allows an officer to use as much force as necessary to carry it out. But listen, this is definitely not a blank check. If an officer crosses the line and uses excessive force, they're no longer protected by the law. In fact, using excessive force can turn an otherwise totally legal arrest into an arbitrary detention, which violates Section 9 of the Charter of Rights and Freedoms. This is a massive deal because it can literally result in crucial evidence getting thrown right out of court. Moving to Section 5, rights upon arrest, the aftermath, and the charter. Once physical control is established by the police, our timeline moves to the immediate aftermath, which is exactly where your crucial constitutional shields are raised. The exact moment you're arrested or detained, Section 10 of the Charter steps in to restore balance to the individual by immediately triggering 2 distinct protections. First, Section 10A, you have the right to be informed promptly of the reasons for your arrest. And second, Section 10B, you have the right to retain and instruct counsel without delay and to be clearly informed of that right. And the courts take that first right, knowing the reasons for your arrest, very, very seriously. I mean, you really can't make an informed decision about whether to talk to a lawyer if you don't even know what kind of trouble you're in. Take the Latimer case as a prime example. There, police basically tricked the accused into thinking he was just in for a minor traffic issue, when they were actually investigating a murder. The courts ruled that if police obscure your true legal jeopardy, you can't make an informed choice. Therefore, they completely violate your rights. As for the right to counsel, Section 10B, it isn't just a single sentence an officer quickly mumbles at you. It actually operates as a strict, step-by-step checklist of duties for the police. These are split into 2 categories. Informational duties require them to read the standard caution and explicitly tell you about free legal aid and duty counsel. You know, the free lawyers available on standby. But just giving you the info isn't enough. They also have implementational duties. They must actually provide you a reasonable opportunity to use a phone in private. And crucially, they have to hold off from trying to elicit any evidence from you until you've actually had the chance to consult with that lawyer. This creates incredibly strict boundaries for the state during what is obviously a very vulnerable time. As the source material highlights, police absolutely cannot act to undermine your right to counsel. This means they can't make disparaging comments about your lawyer, they can't mislead you about legal fees, and there's no way they can offer you some fleeting, exploding plea bargain to pressure you into talking before you've made that phone call. We've explored the foundational rules, the specific exceptions out on the street and in the home, and the fundamental charter rights that govern every single arrest. It's a really complex, continuously evolving system of checks and balances, so I'll leave you to consider this final thought based on everything we've looked at today. In the real world, amidst the chaos of an actual investigation, does the system achieve true balance between state power and individual liberty, or is the scale constantly tipping? Thank you so much for joining me for this explainer, and I hope this gave you a really clear, structured understanding of the mechanics of an arrest.